to our discussion on the critical issue of freedom of speech in Malaysia, specifically through the lens of landmark case Public Prosecutor versus Azmi bin Shahrom. This case highlights the complexity and the challenge surrounding the Sedition Act 1948, a law that has been cornerstone of controversy in Malaysian legal history. The case of Public Prosecutor versus Azmi bin Shahrom is a pivotal example of how the Sedition Act 1948 has been used to restrict freedom of expression in Malaysia. Let's dive into this detail of significant case. The case involved Dr. Azmi bin Shahrom, a law professor at the University of Malaya, who was charged on September 2, 2014 under Section 4 (1) and under Section 4 (1) and (c) of the Sedition Act 1948. The charge stemmed on his comment in an online news article published on a Malay Mail Online on August 14, 2014. The party involved were the Public Prosecutor and Dr. Azmi bin Shahrom. The case began at the Kuala Lumpur Session Court, where Shahrom pleaded not guilty and challenged the constitutionality of Sedition Act 1948. The case eventually reached the Federal Court, which delivered a landmark verdict on October 6, 2015.
The central issue in this case revolved around the constitutionality of the Sedition Act in 1948 and its compatibility with Article 10 of the Malaysian Constitution, which guarantees freedom of speech and expression. Shahrom's lawyer argued that the Sedition Act enacted during the British colonial era was not valid because it was not passed by the Malaysian Parliament. They also contended that the Act's restriction on freedom of speech was too broad and violated Article 10 of the Constitution. So another critical issue was the strict liability nature of the Sedition Act, which makes the intention of the person making the statements irrelevant. This aspect has been highly criticized for its potential to stifle legitimate dissent and freedom of speech.
The article in question discussed a political crisis in the state of Selangor and drew parallels with a similar crisis in Perak 2009. Shahrom was quoted suggesting that a constitutional crisis could occur if the state's chief minister was removed with due process. Shahrom's comments were seen as potentially seditious under the Act, which defines seditious tendency as those that could excite disaffection against the government or promote hostility between different races and classes.
The Federal Court ruled on October 6, 2015 that the Sedition Act and its Section 4 are constitutional. So the court held that the Act was saved by Article 162 of the Federal Constitution, which ensures that the continuity of existing laws upon the coming into operation of the Constitution. Despite this ruling, the Attorney General decided to drop the charges against Shahrom on February 12, 2016. However, the case set a significant precedent regarding the interpretation of the Sedition Act in relation to the Malaysian Constitution.
The case of Public Prosecutor versus Azmi bin Shahrom underscores the ongoing tension between the government's use of the Sedition Act to control dissent and the fundamental right to freedom of speech, guaranteed by the Malaysian Constitution. Critics argue that the Sedition Act is overly broad and can be used to silence legitimate criticism, thereby undermining democratic principles. The case highlights the need for a balanced approach that protects national security while respecting individual rights to free expressions. In recent years, there have been efforts to challenge the constitutionality of certain sections of the Sedition Act. For instance, the Court of Appeal has ruled that Section 3 of the Act, which makes intention irrelevant, is unconstitutional. This ruling marks a step towards aligning Malaysian law with international human rights standards on freedom of expression. The struggle of freedom of speech in Malaysia is ongoing. Cases like Public Prosecutor versus Azmi bin Shahrom serve as important reminders of the need to protect this fundamental right while ensuring national stability and security.